and stay of execution of our ruling, pending formal filing of an appeal before the Court of Appeal. The applicant submits that despite the ruling that has just been rendered, Rule 32 of the Mutunga Rules accords this bench jurisdiction to issue the orders sought, and that there will be no prejudice on any party. They further contend that the Deputy President nominee has not been vetted by the IEBC, which is in any case improperly constituted. In response, the applications have been opposed on the grounds that the court is now functus officio, having already rendered itself on the application for conservatory orders, that the Matthew paper injunction is not a proper remedy in the circumstances, that the Court of Appeal is now seized of a similar application that is for stay, and that this application should have been made earlier, noting that the nomination of the Deputy President designate was made previously. We have carefully considered the applications and responses, and in our considered view, our ruling that has just been delivered addresses these issues succinctly. Not only has the bench gone into great strides to explain the consequences of granting conservatory orders, which is to cause a de facto suspension of a section of the Constitution, we have equally warned against such a practice. To again turn around and grant orders whose effect is the very suspension of the Constitution that we have stated will, in our view, be an absurdity. We further note that some of the arguments that have been raised on the floor will form substantive arguments at the main hearing of the petitions. In any case, since the Court of Appeal is already seized of the matter, as we have confirmed from both sides, the parties have an opportunity to move the Court of Appeal accordingly. As such, the applications are all hereby disallowed. Orders accordingly. And before we pen off, just a point of clarification on the other issues that were raised by two petitioners, Dr. Eboso and I believe your co-petitioner. If you are able to access this ruling, the ruling of today on CTS, you will note that disposition number E states that there will be a mention for further directions on the way forward in respect of pending applications and pending petitions on the 7th of November at 2:30 p.m. in open court. We will address that pending application during that mention. All right?
My lords, we are obliged to the ruling and have a good night.
My Lord, on behalf of the respondents, we want to thank you and appreciate the verdict of the court. Thank you.
Thank you.